Hello there. You're listening to Linda Pinizzato of the Condo Expert, and I got to talk about disputes. Okay, so if you live in a condominium and you have a dispute, or there's disputes arising between yourself, property management, yourself, board of directors, and quite frankly, even if you have a dispute, believe it or not, with security, it could actually blossom into a lot more than you ever expected. So sometimes going in forewarned with knowledge and knowing what's going on in the condominium world is really a much, much better way to address any kind of disputes or difference of opinions. I can go lighter than the word dispute. Hopefully things don't become a dispute, because the point of communication right from day one, if you have something that is concerning you, approach your property management office. Go down and speak with your property manager. That is the beginning of the entire way to handle any type of concern that you have. You know, when people live in condominiums, it's really easy, I guess, to get your back up right away and try to go into this, offensive mode. But you really don't want to do that just yet, because you've got to see where the wind is blowing and how the internal property management and board of directors relationship is. You really seriously do. Because, sometimes if you go up with that, wall in front of you already, it could turn into something that could be very nasty. So take a step back on it. Think about what your problems are. Maybe even put it in writing. And when you go down to your property management office, and sometimes, when somebody reads, just don't mail it in or email it or text it. I don't think you can text it anyway, but don't really. Sometimes what you read and what you hear are two different things. So to avoid any misunderstanding, and even if it means taking off a little bit of time at work to do it, honestly, one-on-one, go down to your property management, call ahead, maybe even set up an appointment to go and speak with property management, and explain exactly what your concern is. And then give them a little bit of time so that they can then go and discuss it with the board, because you can appreciate that the property management office takes direction from the board of directors. So they will require the time to hear what your problem is and be able to address it back to the board. Now, every board has a different way to handle things that they have going on in their building. Some boards are willing to have communication by email. Other boards are not willing to do that. They will only address questions and problems and whatnot at their board meetings. They will not have correspondence with emails at all. So therefore, the property manager may have to say to you, I'm sorry, we have to wait until the next board meeting, but we'll put it on the agenda and we will discuss it at the next board meeting. You may be able to request the property manager to ask the board if they are willing to have you attend the board meeting so that you can, present your own case, which is a possibility. But on the initial stages, I highly doubt that the board will open up the door immediately. It really depends on the situation. Sometimes they would like to get the facts and investigate and discuss it amongst themselves. They may be able to come to an outcome that would benefit you without you having to go to the next step of actually meeting one-on-one with them. So if you do write it down and you have, written down a formal complaint or, just a description of what your dispute is, it is helpful to them. But, and certainly the property manager may ask you to, even if you went and met with him, he will ask you, could you please put it in writing? Because unless it's in writing, sometimes the board may not even take the time to address it. So, and it's paper trail. Hey, there's a lot of value in paper trail. I mean, it doesn't matter what we get involved in, but, if we've got any kind of disputes or concerns or considerations or something, when we're putting it in writing, we show that we're very determined to move forward with it. We're also very organized, and, the dispute that you have is important to you, because anyone taking the time to put it down in writing is showing that they're going to follow it through and they're very committed to whatever their concern is. And commitment means a lot because it also gives the board an idea of how they should probably address it. Because, sometimes you can wake up in the morning and you're just bothered about something. And if that's the case, or maybe you're having a bad day and all of a sudden you've decided to take it out on your board of directors or your property manager, well, that's not the way to work it either. So the next step is that you could raise your concern at the AGM of owners without a doubt, but they're not going to address it. They can't address it. They don't have any information on it. They don't know anything about it. Make sure that you have an AGM coming up. Take the time to let your board know about whatever your dispute is at least 2 months prior to your AGM. Not only for the fact that you're allowing the board some time so that they can get their ducks in order and figure out, maybe they can have a solution for the problem. Maybe they can actually maybe they can have it even before the AGM. But at least give them the courtesy to provide the information to see if something can be done. Raising it at the AGM is really only a grandstand. And not only that, some other owners in the room, they may be looking at you thinking, oh man, what's this person's problem? Like, why are they trying to cause a problem here? Because depending on how you present your case or your concern or your dispute, if there's too much emotion and you look extremely angry, some condo owners may not even come on your side, or they may not even want to listen to your disputes because they figure that you're just a troublemaker. So don't get yourself labeled. And really, seriously, jumping into an AGM and throwing everything out there does tend to label people. Is it fair? Of course not. No, it's not fair. You have an opinion. You have a right to express your opinion. But if there are opinions on the common elements of the building, you're concerned about the cleanliness of the building, you're concerned about repairs that you believe need to be handled, those are all fine. Those are corporation business of common elements that all the owners want to hear about because it's affecting their value. What they don't want to hear about is your problem, your personal dispute, and your issues with either property management or board of directors. Granted, you may have some other condo owner in the audience that thinks, wow, yahoo, this is great because I've got the same problem. But it's not going to get you anywhere because the chair of the meeting generally tends to be the president of the board of directors. Now, if they've brought in a lawyer, quite frankly, I do believe you'd have to be concerned. I always wonder why board of directors feel the need to bring in a lawyer to handle an annual general meeting, because it really, I've touched on that before on some of my other shows, and it's completely unnecessary. It's a waste of money, and unless there's really something that has become a huge problem, a legal problem that the corporation, the owners need to know. For instance, if someone's filing a lawsuit against the board or the building, yes, maybe it would be it would be much better for legal counsel to come in and explain it to the owners. But if we're talking about just a standard AGM where the auditor is there to explain the financials, the board of directors is there to explain what's been going on over the last year, and they're just carrying on the standard normal elections. Plus you have your property manager there who can easily, describe anything that's been going on with repairs or services in the building. What is the need for a lawyer? We're not even talking about any legal disputes here. So lawyers, legal disputes, AGMs, yes. But if there isn't anything of that nature, there's no need for it. So if you do have that happening, you really got to ask the question, why? Why are you here? Why are you chairing the meeting? And also ask how much it's costing, because it's not cheap. And you may want to keep an eye on what your legal bills are on your operating budget, so you can kind of get an inside view if you're not really getting information from your board of directors. But everyone can turn around and say, well, you know what, if you're not happy with it, okay, fine, just go sue. Really? Suing. Superior court, lawsuits, lawyers, mediation, arbitration, any type of legal action. There's an old saying out there about who's the one that gets rich, and it tends to be the lawyers. I'm not going to hit that one, but I will say that honestly, even mediation, arbitration, if you've got parties that are not willing to back down, so if the board is really determined on their decisions, it's going to be really hard, even on mediation and arbitration. If it forces you into legal action, that's going to become even worse. So how do you prevent all of this from coming down? You as a condo owner, every single one of you, if I'm talking to 300 people right now and you all live in the same condo, honestly, pay attention to your AGM. Keep track of things. Can you imagine if all of you saw that there's problems and you all brought it to the attention? I mean, problems in common elements, not internal personal problems. And you brought it to the attention of the board and they're not looked after. And, you know, it's a no-brainer to realize that things aren't functioning properly. So if they're not functioning properly at building level, like common elements level, it's highly possible that they may not be functioning properly at unit owner, unit to board level either. Okay, because, you know, as many of you know, I'm the founder of the Condo Owners Association, and we need, by the way, we need condo owners out there. You guys, honestly, you have to register. Just go into www.coaontario.com/register. $20 a year, register, and build the strength of the Condo Owners Association so that we can help get all of these problems simplified so that they're no longer big problems. And simplified problems are not as expensive as huge problems. All of these huge problems out there and increases on operating budgets and lack of valuable reserve funds in these condo buildings is not helping. And we're moving forward too. I mean, you know, our government is stepping in and saying, okay, fine, we want to see more energy conservation. We want people to be more energy efficient with their lighting. Well, you know, if you want to change the lighting in a condominium underground, for instance, it's going to cost $150,000, $200,000. That's a big contract. That is not a cheap contract. Not only that, depending on when you want to do or when your board decides to do it is another part of the equation. Because remember, if they're not doing it in line with their performance audits and so on, a large amount of it, or maybe even all of it cannot be, the funds can't be taken from the reserve fund. And now all of a sudden you have a special assessment because you're trying to save money on the energy efficiency, which is great because you're saving money there. But you do have to go through the growing pains of the amount of years it takes in order for you to get back the monies that you're saving. However, in the interim, what's it doing? It is affecting your monthly pocketbook. So not everybody can start paying an extra 100, 150, 200, 400, 500. I mean, we've had complaints where people are being hit with $1,000 extra per month to cover a special assessment. So, you know, this is crucial. I mean, you know, it's not something to just look at lightly. And that was one of the reasons why I created the Condo Owners Association. But not only that, the Condo Expert, this radio show. I don't always cover condominium issues. I mean, I branch out into a lot of other different things because, you know, it's like a domino effect. We may be talking about Fintrac. Well, how does Fintrac affect condos? Well, they do. It's all in the process of a purchase agreement, a purchase and sale agreement. So, you know, pets. I've touched on pest control. Well, again, same thing. They're coming back. You can have pests and, you know, all sorts of problems that could show up in condominiums. However, they do also show up in houses and industrial units, anywhere, any form of real estate, quite frankly. So if you're not happy with a lot of things that are happening in your building, absolutely, you have the right to requisition an owner's meeting. You need at least 15% of unit owners, and you have to ask the board in writing to call a meeting within 35 days of the request. But you need to have 15% of units in order for you to be able to do that. And at that time, you can address your concerns. And you've already got your 15% of unit owners that are on side with you because they want to get more information. Now the question is going to be is how do you proceed? Now, if the board is not going to, if they fail to call the meeting within 35 days of your request, well, then you have the ability to hold the meeting on behalf of. The only problem with that is that it prevents you, the Privacy Act prevents you from obtaining the name, address, phone number, contact, any type of information of your fellow unit owner. So unless you're talking to your unit owners in the hallways or in the elevator, or you're knocking on their doors, and nowadays with, it's not uncommon for buildings in, say, downtown Toronto to have, 35 to 40%, maybe even higher, 45% out of country or even out of province investors who lease out their unit. So you have 45% tenants in the building, and you're taking the time to knock on people's doors, and they happen to be a tenant. Well, will the tenant then give you the information of the owner? I doubt it. They may take your information and advise the owner, but if the owner's not here, I guess the question is will they jump in with the concerns that you have? So this process is ridiculously difficult for condo owners to move forward on anything where their opinion and the board of directors' opinion differs. And instead of it being a good conversation between the two parties so that they can come up with, better alternatives to whatever the dispute or problem is, it becomes a closed door issue where you're blocking communication between the owner and the condo board. And the Condominium Act, other than mediation, arbitration, and Superior Court, has no mandate in place with respect to fines or accountability or anything that would force this board to comply. And that's the thing. So does the board of directors have an obligation to speak to you as the board, as an owner? Or at least provide you some kind of answer to your concern or address it or something. Well, they have a fiduciary duty to handle the affairs of the corporation in a proper business-like accountable fashion. So I would think that if something could potentially turn into lawsuits and get that bad, it will not only affect you as a condo owner, but it's going to affect the entire corporation. Downtown right now, there's a number of buildings actually in Toronto and in Mississauga that I know of that have lawsuits. And, they're in the midst. I know one owner in that building, and she's really concerned because she doesn't even get up-to-date information about this lawsuit that's underway. And it's a substantial lawsuit. It's like over $10 million lawsuit. So that's the other question. Because there are concerns with construction, I mean, we had all this business with falling glass. Now we're looking at, intensification studies and all sorts of things. Well, how does anybody move forward if the Condominium Act right now has been put on hold? We've identified a number of concerns. We don't have any type of fining process even listed on this Condo Act review. And we're all sitting back right now just hoping that we will have a better, I guess the title of it was when the McGuinty government set out was called Building a Better Condo Act. Are we building a better Condo Act? I don't think so. Think about that one. Thank you so much for tuning in today. I hope all the information about Fintrac and real estate and agreement of purchases and sales and responsibilities to protect our country and moving forward and taking a look of long-term sustainability with our condominiums and pride of condominium ownership and making sure that we have good legislation in place so that we are all protected. Bottom line. You are listening to Linda Pinizzato, the Condo Expert. Thank you so much for tuning in. Please, if you'd like to be a guest on the show, email me, linda@lindapinizzato.com, or call me, 416-561-7373. Always a pleasure.